Call the regular meeting of the Upshur County Commission to order. We'll begin with a moment of silent meditation and prayer, followed by the Pledge of Allegiance. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. This time we'll have the reading of minutes of the March 21st, 2013 Upshur County Commission meeting.
The Upshur County Commission of the County Commission of Upshur County, West Virginia held their regular meeting at the Courthouse Annex on Thursday, March 21, 2013 at 9 a.m. Donnie Tenney called the meeting to order. There were present Donnie Tenney, Commissioner, J.C. Rafferty, Commissioner, Troy Brady, Commissioner, William Parker, County Administrator, Megan Pomeroy, Assistant County Administrator, and Jacqueline Dinklocker, Secretary. The meeting began with a moment of silent meditation and prayer, followed by the Pledge of Allegiance. All motions passed unanimously unless otherwise stated. After reading of the minutes on motion by J.C. Rafferty, seconded by Troy Brady, the Commission approved the regular meeting minutes of March 14, 2013, as submitted. Alicia Rapkin, Crosslines Director, appeared before the Commission and provided an overview of services provided by the agency. Crosslines provides assistance to low-income recipients in the form of food, clothing, transportation, and monetary help for housing/utilities, furnishings, medical, and educational needs. Ms. Rapkin expressed appreciation for the continued support of the Upshur County Commission. Ms. Rapkin provided financial data and requested funding for fiscal year 2013-2014. The Commission will review and consider the request during budget meetings. Greg Harris, Director of Facility Operations, appeared before the Commission and requested the purchase of a utility tractor for maintenance projects. Mr. Harris provided information to corroborate the need for the new equipment. Mr. Harris has obtained cost estimates from several sources as follows: L&T Farm Equipment, Incorporated, $21,583. State Equipment, Incorporated, $22,200. Middletown Tractor Sales, $22,267.47. And Burrs Power Equipment, $23,933. Mr. Harris has made a recommendation to purchase a John Deere model at a cost of $22,267.47 from Middletown Tractor Sales in Fairmont, West Virginia. After discussion, the Commission requested Mr. Harris to obtain an additional quote from the John Deere dealership in Flatwoods, West Virginia, before making a final decision. After discussion on motion by J.C. Rafferty, seconded by Troy Brady, the Commission approved to provide a letter of support for the Buchanan River Watershed Association's Smooth Rock Lick Acid Remediation Project. William Parker was requested to follow up. Mr. Parker provided an update concerning repairs to the West Virginia University Extension Service, Upshur County office, which resulted from an automobile accident. After discussion on motion by Troy Brady, seconded by J.C. Rafferty, the Commission approved and authorized the President to sign the contract with Reliable Builders in the amount of $19,400 for the repairs. The cost of the repairs fully covered by the insurance carrier of the at-fault driver. After discussion on motion by J.C. Rafferty, seconded by Troy Brady, the Commission approved William Parker as the Upshur County Commission representative to the Upshur County Convention and Visitors Bureau Board of Directors. Mr. Parker's term will end May 2016. After discussion on motion by Troy Brady, seconded by J.C. Rafferty, the Commission approved the employment of Richard Frederick Dilly as temporary seasonal groundskeeping personnel, as recommended by Greg Harris. Effective date of employment is March 31, 2013, at the rate of $8 per hour. After discussion, a motion by Troy Brady, seconded by J.C. Rafferty, the Commission approved the employment of Deborah K. Carlisle as full-time administrative assistant at the WVU Extension Service Upshur County office, as recommended by Gary Rapking, Extension Service Director. Ms. Carlisle's effective date of employment is April 8, 2013, at the rate of $8 per hour. William Parker provided a review of the request for a pay increase for Michael Wayne Campbell for full-time Maintenance Department personnel from $11.58 per hour to $14.18 per hour. Mr. Campbell has recently obtained his license as journeyman electrician. After discussion, a motion by J.C. Rafferty, seconded by Donnie Tenney, the Commission approved the wage step increases for Michael Wayne Campbell as follows. March 24, 2013, increase from $11.58 to $12.88. June 16, 2013, increase proposed 2% minimum, $600 to $13.16, which is contingent on the approval of the budget. And September 22, 2013, increase from July 5th check rate to $14.46. Pay increases to be based upon successful job performance and maintenance of HVAC and electrician's licenses. William Parker provided a review of the request for a pay increase for Megan Jane Pomeroy, Assistant County Administrator, from $32,500 per year to $37,550 per year. After discussion, a motion by J.C. Rafferty, seconded by Donnie Tenney, the Commission approved the wage step increases for Ms. Pomeroy as follows. March 29, 2013, increased from $32,500 to $35,000. June 23, 2013, increased $700, proposed 2%, contingent on approval of budget. And September 29, 2013, increased from $35,700 to $38,200. Pay increases to be based on successful job performance with additional job duties and responsibilities. Troy Brady expressed concerns about the inequality of increase of pay rates for other county employees. Donnie Tenney recognized Jerry Kimball, Upshur County resident, as a loyal attendee of the Upshur County Commission meetings. Mr. Kimball has been regularly attending meetings for over 3 years. Donnie Tenney advised of a grant award to the Upshur County Circuit Clerk's Office in the amount of $12,000 from the Records Management and Preservation Board, West Virginia Division of Culture and History. Funding will be used for the purchase of a shredder and imaging of Chancery records. William Parker advised the Commission of an ethics ruling that henceforth a listing of invoices will be included with the minutes. The Commission reviewed the following for your information items. Number 1, notice of public hearing, amendment to enhance 911 ordinances, 11 a.m. on Thursday, April 4, 2013. Increase from current monthly fee of $2.65 to residential $4.50, business and Centrex $6.50. Number 2, correspondence from the Division of Justice and Community Services, receipt of Juvenile Accountability Block Grant, $15,000, Victims of Crime Act, $34,175. Number 3, Upshur County 911 Center reports as listed. Number 4, Upshur County budget hearings as listed. Number 5, agendas and/or notices of meetings as listed. Number 6, meeting minutes and/or financial reports as listed. Number 7, meetings as listed. Number 8, appointments needed or upcoming as listed. The Commission approved all invoices for payment. The Commission approved all vacation orders. The Commission approved the following settlements as listed. The Commission approved the following exonerations and/or refunds as listed. The Commission approved the following consolidation of land tracts as listed. The commission recessed at 11:30 a.m. Commission reconvened at 1 p.m. Greg Harris, Director of Facility Operations, appeared before the commission and provided further information concerning the purchase of a utility tractor. Mr. Harris obtained an additional quote from Flatwoods Lawn and Garden Supply in the amount of $21,400. After discussion, a motion by J.C. Rafferty, seconded by Troy Brady, the commission approved the purchase of the John Deere tractor from the Flatwoods location. With no further business, on motion by J.C. Rafferty, second by Troy Brady, the commission meeting adjourned at 1:15 p.m.
Are there any additions or corrections to the minutes as read? If not, I'd ask for a motion to be approved as such.
I'll make that motion.
I'll second it.
All in favor say aye.
Aye.
Opposed, same sign. Motion carried. Thank you, Jackie. And we'd like to thank Jerry for suggesting we call the other John Deere dealership, which did underbid the first one, and the first one we had said that he didn't understand how they could sell it for that price because he wasn't making any money, but we're certainly appreciative of Jerry and appreciative of the fact that possibly the dealer didn't make any money, but it saved the taxpayers of Upshur County money, so.
You need to get another name tag and put Jerry.
That's right. Well, he's,
When do your council meetings occur there? Thursday evenings, is it? Rob?
maybe you should go down to the council meetings, Jerry. Is he there? Okay. Okay, we have Joyce Harris Thacker, Solid Waste Authority Board Member, proclaiming designating April 2013 as Make It Shine Month. Joyce, would you like to step up?
Well, don't go so far away.
He's shy.
He's backing you up way back.
I know better. He's not shy, and I'm not either. We appreciate very much the opportunity to be here today to ask you all to participate in proclaiming April as Make It Shine Month, and we'd like to proceed with the proclamation, and then we have some information about upcoming events and activities in April along the line of making our community in Upshur County shine.
Go ahead.
April 2013, Make It Shine. Whereas the Upshur County Commission is aware that West Virginians are taking action to work towards the common goal of a clean, safe environment for this and future generations. And whereas one of our most critical objectives must be to reduce the volume of solid waste being generated by our citizens and being disposed of in landfills. And whereas our legacy as a county, as a state, and as a people rests on our ability to clean up the environment and set the standards for ourselves and future generations. And therefore, we, the Upshur County Commission, do hereby proclaim the month of April 2013 as Make It Shine Month. The Upshur County Commission urges all citizens to participate in programs that would accomplish these objectives. The Upshur County Commission would encourage participation in Adopt a Highway and Adopt a Spot programs, given under your hands this 28th day of March 2013.
Do we have a motion to approve the proclamation as read?
So moved.
Second.
All in favor say aye.
Aye.
Opposed, same sign. Motion carries.
Thank you. And I'm going to let Burl update on the programs and activities that we have coming up, and then there'll be a couple other things that I'll want to add as well.
Come Monday, April Fool's Day, everybody's going to be very happy with the nice weather, getting into the mood of cleaning up and making things look better. There are a number of things that are happening that are the same thing that happen each year that we've done, but one of them, there will be a billboard sign out on Route 33 that depicts a BU middle school student's rendition of some recycling information. So look for that. We'd encourage you to look for that. On April the 19th and 20th, there is a celebration of recycling at Crossroads Recycling. That will be from 10 o'clock on Friday until 6 o'clock that evening, and then on Saturday from 9 until 2. But on Saturday, there is also a free, emphasized free, shred event for paper shredding for individuals to bring all kinds of personal type papers, anything from canceled checks to old love letters or whatever that could be shredded there on site. The shred approximately about 6 ton of paper, so it will go very smoothly. The Centus people will be conducting that. It won't be our local people, and they will have the security for the papers. And we do encourage you to stop by that Friday and Saturday to visit the recycling center there at Crossroads. We have some giveaways. I think Joyce may have brought a few of those things away or here today also. But we encourage you, really support the cleanup of Upshur County. And we know you do by signing this proclamation. And I encourage you to join and adopt a highway group. And that would be a good item for you. Do any of the commissioners now participate on Adopt a Highway group?
When the Rotary has had it in the past, I've participated.
I clean up about 3,000 feet along Tomsville Road.
Okay. Well, there's a program, and you can still register until April the 12th with the Adopt a Highway group from DEP for an Adopt a Spot, and you can receive some special recognition for keeping your road frontage picked up that way also.
I have a question, Burl. On the shredding date, not being a pessimist, but in the event of adverse weather, do you have a rain check date or another
We
date?
have shelter.
You have a shelter,
We
okay.
have shelter. They will bring in a huge box truck, and there will be a canopy so that the weather won't stop that event that day.
Very good.
Yeah, I think the last time that we had a shred event, it was very windy and it was cold, but we still were able to have the event and a lot of participation in that. I did bring, and I can get this to you online as well, an application for the Make It Shine cleanup for adopting a spot in a section along our highways or in our park locations. I did want to announce that I'm part of the Arch Coal Advisory Panel, and I have, through this program and REAP and DEP, we are going to have a cleanup of the Sago Road, the Arch Coal Advisory Panel and employees on April 1st, next Monday evening, and we'll be starting at Route 20 and going all the way up Sago Road to the mine site. So I wanted to make that announcement. Anybody who wants to join us, when you participate in this program, you can get gloves and bags, and then they'll be bringing vests, so we're identified as being along the highway. So, you know, those concerns, you know, you don't have to worry about, and then they coordinate with the DOH to come by and pick up the litter. You know, when the snow finally goes away, that's when you really, and you're traveling along the highways, you see the litter from throughout the winter that people have discarded out their windows when you're driving along, or it's just horrible. And now's the time to get involved and get along those highways, and you have folks that will participate in giving you the equipment that you need to participate in that. So we would encourage that, and we'll leave the information that you can share in order to sign up and to get assistance with the equipment that you need to do those events.
What percentage of the highways are under the adopted highway program? Do you know, or how many miles in Upshur County?
There are probably 20-some groups actively participating now. There have been many more groups over the time that have participated, but at 2 miles per group, that would give you a rough estimate of how many miles are adopted. I am proud to say that last Friday, the Hickory Flat Road Neighbors, that's the name of it. I live out on Hickory Flat Road. We had 11 participants on the Adopt a Highway, our initial pickup, and we picked up 18 bags of litter along that 2-mile stretch. And it looks so much better. It just feels good to drive along the roadway and see how much better it does look.
So the amount that's picked up is measured every year so you can compare from year to year as to whether there's less garbage as time goes on, or?
There is a report of every pickup sent to the Adopt a Highway program people in Charleston, and I'm sure that they have computerized lists of how many bags are picked up at a certain period of time, and they can make comparisons.
Do you think there's less thrown out now or more?
I think we're better at it than we used to be. We probably deposit more litter than we ever have, unfortunately. But there is an effort made to it. A lot of litter comes from people intentionally just throwing something out of the window. But a lot of it is we have so many pickup trucks here in Upshur County, a lot of stuff will blow out of the back of a bed of a pickup truck also.
Okay.
I know, as a general rule, when we're here doing this, that you all have questions about the amount of recyclables that we have and people participating here in Upshur County. And I asked Burl to bring that information with him in case you all have questions about that.
I think Joyce is insisting that I give you those numbers.
Because usually you ask and I say, I don't know, but I know people that can. I'll get that information for you.
As an example of how much waste is collected in Upshur County, the city of Buckhannon will collect somewhere about 14,000 tons each year, or 14,000 tons each year. And we recycle, the city of Buckhannon recycles about 700 tons of recyclable material, which would include papers, the plastics, steel and aluminum cans, and newspaper and cardboard, and even yard debris. So there's a lot of things recycled in Upshur County. And if you start thinking about 700 tons, that's 35 tractor trailer loads of recycled material coming out of Upshur County each year. That's quite a bit.
Okay, any questions for our two recyclers?
Just keep up the good work. And I've been by my farm up there, and I picked up all kinds of trash there the other day on Route 20. So keep up the good work.
Okay. Joyce, you have something?
I have some goodies for you all that I'd like you to share with the group.
Do we have the resolution? Do we have the resolution to sign?
Yes. Do you need that?
Is that the official copy?
She's going to give us the original.
Oh, she's got the official
Yeah.
copy of it.
Recycle. Jay,
Thank you.
for you.
Oh, thank you very much. I put it on the side.
Forehead.
Oh, I got two.
Do you want? See?
Thank you.
Put your button on.
Thank you, sir.
I brought these, you guys share those with the group as well.
Thank you.
Yeah. Let you get here.
Like Amanda wants to get a picture.
Oh,
Yeah.
She does.
wasn't there an assassination or something that had to go in the camera?
You would worry about things like that in your line of work.
I do.
Thanks, George.
Thank you all very much.
Thank you very much, Joyce. Appreciate your efforts.
Mr. Parker. Okay, at this time, we have William A. Parker and/or Cheryl J. Parker concerning concerns regarding probate for the estate of Kenneth Parker, deceased. At this time, Mr. Parker is stepping out of his role as county administrator and is here as a taxpayer and citizen of Upshur County. Citizen Parker, go ahead. Thank you.
Thank you, gentlemen, for the opportunity to appear today. And as you said, I'm here as a private citizen today along with Cheryl, my stepmom. We are appointed co-executors under my father's will. And this is not a function as the county administrator. This is, an item concerning the estate of my dad. This is not an attempt to cause any undue problems for the county commission or embarrassment for the commission or the county clerk. But one of the things my father taught me was to question government, ask why sometimes. I lived that experience in opposition to a construction of a Stonewall Jackson Dam project in Lewis County. In fact, the U.S. Army Corps of Engineers, I think, hung a title on my father, a square yard Parker. He took an acre of his property, our home place, divided up into square yards, 44,000 plus square yards in an acre, and sold those square yards and had deeds prepared in an effort to fight opposition to that project. As you can see, we were unsuccessful because there is a dam over in Lewis County. But it's a duty and responsibility, I think, of the citizens to question the administration of government. I have a quote from Abraham Lincoln I'd like to give you. It says, "There is an important sense in which government is distinctive from administration. One is perpetual, the other is temporary and changeable. A man may be loyal to his government, yet oppose the particular principles and methods of administration." And what is government? Henry Clay gave us a definition of government. Henry Clay was representative from the state of Kentucky, House of Representatives, U.S. House of Representatives, and Senate. He was Secretary of State, 1825, three-term Speaker of the House, founder of the Whig Party. 1957, the Senate named him as one of the 5 greatest senators. But his definition of government is as follows. Government is a trust, and the officers of the government are trustees. And both the trust and the trustees are created for the benefit of the people. And I think that is a very good definition. But we seem to be having some difficulty in getting questions on the administration and procedures of estate matters, at least in my case. I submitted a holographic will of my father on Friday, March the 22nd. I have a handout that was provided to you from Ms. Pomeroy that I provided to her this morning. But the first is from the first page is West Virginia Senior Legal Aid Incorporated, and it defines what is a holographic will. And it's entirely handwritten by the testator or the individual. And for a holographic will to be valid in West Virginia, there are 3 requirements. First, the entire will must be in the handwriting of the testator or the individual. Any words not in their handwriting will be excluded from the will. Second, a holographic will must be signed by the testator with either a signature or a mark intended as a signature. The will does not have to be signed by any witnesses. The third requirement for a holographic will is that it must have testimony intent, the intent to distribute property. If a holographic will is never contested, the will is valid and all the property will be distributed according to will. And then they give you a cautionary note as it relates to holographic wills. The second page that you have in your packet is a holographic will legally binding, and it outlines the states that they're binding in, West Virginia being one of those. Roughly half the states in the U.S. recognize holographic wills as legally binding. And there's certain parameters where some states recognize it for military personnel. Whether a holographic will on page 3 is witnessed or unwitnessed. Many states recognizing holographic wills do not require attestation or witnesses, while others do. West Virginia is one that does not require that. It has to be in their own handwriting, as I said. Page 4 of the packet starts dealing with some of the statute that I've tried to research, and I've been in contact with the Office of the County Clerk, and they have requested that the signature be verified. As I understand it, Ms. Wilfong can speak for herself, but as I understand our conversation, they've requested that the signature be verified and that my father's mental capacity at the time of drafting the will be attested to. The codes that I have researched that I'll outline here for you, I have not found that requirement. In fact, I've found the exact opposite, unless there's something that I have overlooked, and that's a possibility.
You refer to codes, Mr. Parker, referring to West Virginia statutes and codes?
Yes, West Virginia statutes starting on page 4 there of that handout. And I asked Ms. Wilfong for that verification of what statutes is driving her decision to require that. On 3 different occasions, she's given me 3 different items to look at, and that did not deal with requiring witnesses or verification or the validity of a holographic will. In fact, one of the court cases that I was referred to is Charleston National Bank versus Through the Bible Radio Network. That is not in your packet. I did not copy that. But that dealt with a holographic will where there were notations made after the will was signed by the individual in their own handwriting. The court upheld those notations, which changed the bequeath changed who was getting the money in this case. So that was a major change. The other part, they had typed a name and address of this organization. The courts threw that out because it was not in their handwriting, but they upheld the validity of the holographic will because it did not substantially change the will, that typewritten material. But that case is available if the commission would so desire to review that. But page 4 talks about starting with chapter 41, sections 1, 2, 3, and 4 you have there. Must be in writing and witnessed, 41:1-3. No will should be valid unless it be in writing and signed by the testator or by some other person in his presence by his direction. So if you, as I understand it, if you type a will, have someone write the will for you, that's not an attorney. We're not talking about an attorney drafting a will at this point. We're talking just about lay people. That will would have to be signed by the individual as well as 2 witnesses. Still, if there's a situation where that will would need to be signed, there's no attestation required, as I read this code, for those witnesses. They are swearing to each other before the presence of that individual that, yes, this is his signature, yes, this is my signature, yes, that's the other witness's signature, and the will is valid as I understand it. But that's not the case here. My father's will was in his own handwriting. If I remember right, it was drafted in 2008 was the date of that. Page 5 starts chapter 44, 1-1. And here's, one of the issues we have, because an executor has no powers before qualifying. Cheryl and I have no powers basically to do much until that will is accepted through you gentlemen. You are the ultimate decision on probate matters in Upshur County. And so far that has not happened. There can be certain things you can do. You can pay burial expense, take measures to prevent waste of the estate, and et cetera. 44:1-3 talks about oath of an executor and whether an administrator with the will annexed. That was one of the codes I was referred to in requiring signatures. If a will is annexed, that means there's no executor appointed, or the executor has failed to qualify or refused to qualify. This is not the case in my father's will. We stand ready, to qualify as executors of the estate. But a will is annexed. It talks about will being annexed in those individuals' situations. Again, page 6 is more of chapter 44 and filling, what's required of the executors. Page 7, 44:1-14, appraisement of the real estate, probate personal property, and it talks about the non-probate inventory list that is to be included. Ms. Wilfong and I briefly discussed the non-probate inventory list, and I have some concerns about, as I understand the practice in the past for Upshur County, there's to be a non-probate inventory prepared by the executors of the estate that is personal and confidential information. It's to be filed with the state tax commissioner at state tax department. I have contacted the state tax commissioner just through their help desk. The individual that I spoke to says, we're required to get them. We really do nothing with them once we receive them other than have them on file, was his comment. Page 9 talks about what non-probate inventory of estates, what must be listed. And one of the items that I did discuss briefly with Ms. Wilfong, it was just very briefly, that I had preliminary, because I filled out preliminary forms already for my father's estate for the office of the county clerk. Normally they get those ready, set an appointment, you come in, review that information, sign off on those, they give you the oath, et cetera, et cetera. But one of the things that I listed on the non-probate inventory of it that does not need to be there and needs to be removed is the insurance life insurance payable to Cheryl. My stepmother was the beneficiary of all the life insurance my father had. And as you can see under 11.11.7, item 4, insurance on the decedent's life payable to beneficiaries must be listed. Then it adds this little other phrasing, other than the executor or administrator of the decedent's estate. So you do not need to list life insurance that's payable to an executor of the estate on the non-probate inventory. Item 10 deals with the confidentiality and disclosure of returns and return information. And that's what's referenced back in chapter 44. It's a violation of statute for this information to be released, similar to a property tax assessment through the Office of the Assessor. I'm not sure what Ms. Wilfong's practices in the past of the non-probate inventory, why her office keeps copies. If those are mailed, or if they've been mailed in the past, it's a violation of statute. And you gentlemen, that's up to you whether you follow through with that with your clerk. But pages 10 and 11 and 12 deal with that, and also 13. And page 14 deals with the personal representative of the estate, the privacy of the information, and who may receive the non-probate inventory list. The personal representative of the estate is the one that makes that available to any heir at law, beneficiary under the will, a creditor who's filed a timely claim against the estate, and et cetera. That's not a function or duty of the office of the Upshur County Clerk nor the Upshur County Commission. That's a duty of the personal representative. So I see no reason why the County Commission or the Clerk of the County Commission would keep a copy of that on file for review, because they're not to be open to the public, and where they're stored right now, the public can get to them. And that is a situation you may want to follow up on. There seems to be some confusion of how many times I talked to Ms. Wilfong. She was present at all the discussions we had, except for one that I had with Ms. Reeder on Monday, the 25th at approximately, 1:30 or so. And I just requested an update from Ms. Reeder as whether the will had been accepted yet or not, or if the attitude had changed on the acceptance of the will. And Ms. Reeder advised me that it had not. I do have some concerns when Ms. Wilfong has contacted my employer as it relates to this matter. I'm functioning as a private citizen. I'm not functioning as the county administrator in this matter. I don't know how many other employers she's contacted in the past if they've questioned her authority or interpretation of the code, but that is clearly out of line. And I don't know why that would happen. One, two, or all three of you may be upset that I'm appearing here today, but that is my right. I don't know if it's an attempt to create a hostile work environment or what the situation is. I know the clerk of the county commission has been in contact with law enforcement personnel, according to the discussion I've had with the sheriff. Don't know why that happened. It's happened. One of my commissioners informed me that she had told them they'd been in contact with law enforcement personnel. Ms. Wilfong had a discussion with the sheriff and the chief deputy of administration late Tuesday afternoon, approximately 3 or 3:30. I don't know if it was an effort to get the sheriff to administer the state, which is not a correct interpretation of the code at this point, in my opinion, or a pressure to follow up in their official capacity as law enforcement personnel. Cheryl nor I are interested in pages 15 through 18 of your handout, which is chapter 667, which deals with possible official misconduct and a neglect of duty. Our interest is in finalizing the estate of my father. This is causing problems, emotional distress, health issues for Cheryl, mainly. I can take the emotional distress. I'm a big boy. Cheryl's the one that's lost her husband. I lost my father. And this is not helping the situation for any party involved. I think the government should be here to help people through these situations, not make it more difficult. My request of the commission is as follows. An order of the county commission directing your clerk to omit the holographic will of my father or provide written documentation referencing the statutes of why it cannot be omitted, which would require witnesses or attestation. Provide references to statutes that require filing within 30 days of his date of death, which was November the 30th, 2012, on his 80th birthday. I have not been able to locate that. I was told that he had 30 days to start the process. That may be correct. I've not done a lot of research on that. I have not found that in statute anywhere. I don't know if that's a practice. Maybe it's out there. Don't know. Have not found that. I requested Ms. Wilfong on Wednesday via just a phone call to her office, to her extension, for that statute. She said she would have to look it up and get back with me. The non-probate inventory list we've discussed a little bit. We've talked about the life insurance. I was told I would need verification from the bank on bank accounts at the time of his death. And as you gentlemen may know, you can contact your bank on any day and they will give you a bank balance, but that may be not a correct balance unless you do a reconciliation of deposits that are outstanding or checks that have not cleared yet. So a bank balance in itself, or a bank statement in itself, does not verify a bank balance at the time of his death on November 30th, 2012. That's my responsibility. Cheryl's responsibility as executors to provide that information and swear under oath that that is the correct amount. If that is incorrect, then it's up to an heir or beneficiary to challenge that. That's their responsibility to challenge that, somebody that is a legal heir or beneficiary to the will. And I would also like, cease and desist of actions creating a hostile work environment, information, pressure or direct action to employees that would cause a negative effect or impugn my character or reputation, actions to interfere with the performance of my job duties. Those are separate issues. They have no bearing on this matter whatsoever and should not be involved. I don't know why some phone calls were made to commissioners, or all one, two, or all three, or law enforcement personnel. Separate matter. I will assure you, gentlemen, I will persevere in this matter. I'll be professional. I'll be positive. And I'm asking the same in return. Actions otherwise cause additional emotional distress and health issues for individuals that are involved in this. The lady has lost her husband. I have lost my father. And lack of professional positive actions affects everybody, much more than me. I would ask for an immediate request from the County Commission to draft an order directing your clerk of the County Commission to accept the holographic will, ensure other individuals are not subject to the unnecessary, unneeded, and items not required by statute. I'm not the only individual that must go through this process. This is evidently a standing process within our county. And in my opinion, it's not needed or required by statute. Cheryl is here and can make additional comments if she'd like, or she's indicated she's going to leave the speaking to me. Or if you have questions for I or she, either one.
Well, I think you laid out your concerns. I think unless one of you gentlemen has a question for Willie or Cheryl, then I think it would be appropriate this time that we ask the county clerk if she'd like to respond and to these and give us your code for your decisions.
Good morning.
Morning.
Okay. First of all, I didn't get to write down everything that he's wanting, but to make the will to record, and I have talked to the majority of the clerks around the state, fiduciary commissioners, and to John Hustle, who is does our probate training. Talked to him this morning, and actually he gave me his cell phone number if we'd like to contact him. He was on his way to Martinsburg. That I cannot omit the will holographic will unless it is verified by witnesses proving that that will is that man's signature or any signature on a holographic will. It has to be proven that there is a signature. Now, he said to me that they've been taken to court. There are court cases verifying that. Like I said, he was on his way to Martinsburg at the time, and he will give me other cases of it. He also, now he did say Charleston National Bank through the Bible, which Mr. Parker brought up, through the Bible, I forget what it's called there, that is a court case that he tried in Charleston that does prove that you have to have two witnesses verify the signature. It's a court case that he actually tried himself. And that court case does prove that. Now, I do not have that court case with me, and he would be glad to discuss this at any time with you all in any matter. But his, excuse me, his thoughts to me on the phone was that I cannot admit this will to record unless it has been proven as to the signature.
So does that conflict with the code? Are you saying something different than what the code says, or?
He said there are court cases saying you cannot admit a will to record without the signature being verified. That would be just.
And that it's in the handwriting of the testator.
Yeah, right.
I got a Supreme Court case, the most recent one, that's what it says.
It's a holographic will.
That says what now? That the will has to be written in the handwriting of the one making the will, and then they sign it in their signature. And if that's the case,
maybe Mr. Reed should. Do you mind coming up to the podium, Mr. Reed?
I don't know why we're here. This is a very simple matter. It can be easily resolved. The law has always been, and it's always been the practice, that it's governed by 4113, which says for holographic wills, two requirements. Number one, it has to be wholly in the handwriting of the testator. Your niece cannot write out your will in her handwriting and then have you sign it. We require that it be wholly in your handwriting to establish that that was truly your intent. You have to be careful with wills because the person involved isn't here to raise an objection or tell you what he meant. He's dead. So we're required to be wholly in the handwriting. Now, we can't exclude non-handwritten letters, words, if it doesn't detract. Used to be if you wrote your holographic will on your letterhead, there's writing on there that's not in his handwriting, the letterhead, Upshur County Commission. It's not valid. The Supreme Court said you can omit words not in the handwriting of the testator as long as the body is in the handwriting of the testator. That's in the code. Number two, it has to be signed. Now, how do you prove this? First of all, you're the ones who admit it. The clerk may have talked to you, but you're the ones who admit it. Even when it's admitted the short form before the clerk, it's brought to you. To admit it, the law requires that the person submitting it for probate produce two witnesses who will verify two facts after establishing that they are familiar with the handwriting of the decedent. They have to verify and affirm in an affidavit that that will is solely in the handwriting of the testator and that it was signed by the testator. Typically, if you can't find anyone else, you would use bank officers because they have signature cards, which is good proof of signature. We know the person signed it. But to answer your question, the most recent case in this state is Rubble versus Rubble, or Rubel versus Rubel, July 6, 2005. This involved a Monongalia County holographic will. In the facts of the case, the Supreme Court said they followed the correct procedure. And what is that procedure? Submitted with the will were the affidavits of two witnesses, Jerry Walls and Susan Johnson, verifying that they were acquainted with Ms. Green during her lifetime and were familiar with her handwriting and signature, and that, and this is the key, they believed the handwriting and the signature on the holographic will was that of Ms. Green. In other words, the Monongalia County clerk, as I think every single clerk in the state, because it's required by law, requires you to produce 2 witnesses who verify that it appears to them that the handwriting is that of the testator and the signature is that of the testator. We have similar analogous provisions regarding typed wills that have witnesses but don't have the self-proving affidavit. We require them to sign an affidavit that they were requested to be the witnesses by the testator, that they, in the presence of each other, observe the testator sign. In other words, this affidavit is to give a legal basis for submitting the will to record. Now, this whole problem, we can solve this problem, bring in 2 witnesses who say, yes, that appears to be the handwriting of Mr. Parker, and that appears to be his signature. I'm sure he had a bank accounts here in Buchanan. You can get 2 officers from that bank who will be more than glad to come in and do it. We're taking a lot of time when this problem can be solved with about 5 minutes worth of work. Now let me go through a couple of other things. First of all, there was a question raised as to whether, in fact, I'll leave this case with you. There was a question raised as to whether the will had to be admitted to probate within 30 days. 4151 provides that within 30 days after the death, the will must be submitted for probate. I have a copy. All the fiduciary commissioners are here today in support of the position of Mrs. Wilfong. You just happened to pick on me first. But I do have the list that was sent out to everyone. Verification of bank balances. We've always required, I think all counties require, you to get a verification from the bank of the bank balance. You do not accept anything other. The banks have a little form that they will fill out. You get that. You do that to establish the accurate amount. Let me share with you a problem we had in this regard within the past few years here in this county. Woman, in fact, she may still be in the penitentiary for embezzlement. She was the administrator of an estate. The fiduciary commissioner, who's now retired, required her to submit balances of the accounts. She came in with a list in her own handwriting. He said, no, you need to get it from the bank. She hum-hauled around, came back later, didn't have them. So eventually he went to the bank and got the forms from the bank that listed the amounts. And there was a gross difference, and the difference being what she invested. If we had not required the production of bank verified balances, that would have gone undetected. She was indicted, convicted, went to the pen. Most of you, some of you may know who I'm talking about. The bank balance on the inventory, we recognize that there may be a variance, that there may be 2 checks outstanding. You simply show that on the final settlement. Okay, so if the bank shows that you have $12,300 in the account as of the date of death, then there are 2 checks that come in for $200 a piece. Then you would show $12,900. You would show those 2 checks on your final settlement. Life insurance proceeds, the issue raised on that. I'm not sure what is being referred to, and that may be part of the problem. If it is a policy payable to the estate or payable to the administrator of the estate in his capacity as administrator, then it has to be listed on the appraisal, Schedule F. The appraisal form specifically says that. It is correct. If the insurance policy is made to an individual, then it's not part of the estate. It's not listed. But if it's made payable to the administrator in the capacity as administrator, life insurance typically don't make a check out to the estate of so-and-so. They make it out to Mary Smith, administrator of the estate of Joe Smith. So if the policy and if the check is payable to the administrator of the estate in that capacity, the law requires that it be put on the appraisal. Or if it's made out to the estate.
Or to a named beneficiary, it goes into the non-probate.
Right. So, you know, that's my thoughts. This problem, we can solve this problem very simple. Just bring in 2 witnesses, have them sign an affidavit. Let's go on about our business. Prepare the appraisal, get the bank verifications, submit it, get it approved. I don't know why we're here.
What's your legal opinion, Terry, on the question about the information and whether it's confidential and who can be sent to and where it can be kept?
Well, it is confidential, and it is not to be mailed out to the public. But she's governed by the state tax department rules and regulations, and I don't know what those are. Remember, we have the code. Then that is expanded upon by the Supreme Court decisions. They're the ultimate authority. You got that there. The code is a little ambiguous. That Supreme Court case is clearly unambiguous. But you also have to comply. The code requires that the tax commissioner, and in some cases the auditor, have certain regulations, practices, and procedures. And I'm sure your county commission, I'm sure you have to go through a lot of things that is a state tax department requirement. They have to get it. They have to send it in. I would say that it should be, in my personal opinion, kept in a secure place by the county clerk for a period of at least 1 year after the date of death, because that will can be challenged. That estate can be challenged up to 1 year under certain circumstances. So I think that the records should be kept. And so there's a record in a file in the clerk's office. I mean, what harm is done with that? If it needs to be produced before the county commission for an official inquiry, it's available.
So there's a copy that's sent to the state, correct?
Correct.
And then you keep, how long do you keep your copies here?
Our copies, we have to keep our copies. The original files on that estate, we keep them forever.
Keep them forever?
Yes, and they're locked up in the back room. The others that are current are in my office.
But once the estate's settled, then they're locked up in a secured room?
Right.
Does anyone else have any of the other fiduciary commissioners have anything you want to add?
I simply endorse Mr. Reed's comments, Ms. Wilcox's position, and the practice of the 2 attesting witnesses to the signatures actually began, gentlemen, in 1987 as a result of the Siebert versus Sanders case. So Mr. Reed presented you with the most recent case. I simply have the originating case. As we're all aware, when the Supreme Court makes a ruling, it doesn't modify the law. It's just not the way it works, so that would be terribly practical. It expands the law and further explains the law. And so perhaps Mr. Parker, by only looking in the code, was limited in his knowledge base. And so I have the original case if the county commission thinks it's relevant. Obviously, the most recent case is, in my opinion, the most relevant. But that practice is since 1987 by the Supreme Court's direction, gentlemen.
So a handwritten will doesn't have to be witnessed, but it has to be proven that it was in their handwriting. Is that
correct? There are no witnesses required for a holographic handwritten will, but you do have to prove by competent evidence, being, as the Supreme Court said, 2 affidavits from 2 people, that it was in that person's handwriting, appears to be, and that appears to be their signature. You just can't bring in a paper and say, this is Grandpa's will, admit it to record. I got to establish the legal basis of it before she can act, and she really only acts for you because you're the one who eventually stamps it and admitted it. Therefore, any conversation she had with you as a clerk, it's not as an employer. I mean, you're the one who makes the decision if I were a commissioner and a clerk wasn't discussing and keeping me advised, I would be upset.
Gentlemen, have any questions?
No, does Mr. Parker have any additional information?
I would concur with some of the information. It's a matter that could have been resolved in 5 minutes or so. I've asked Ms. Wilfong on 3 different occasions for the information that was provided here this morning. I'll review that information. I've requested that and have not received it. As it relates to witnesses and signatures, in January 2012, my father came in and had a power of attorney witnessed in her office by 2 of her employees, notarized by another one of her employees. I offered at that time, when I presented the will on Friday, I said, there's 3 employees in your office that have verified my father's signature in January 2012. She said that was not satisfactory. If they can verify his signature in 2012, I don't know why they cannot do it now. My father had ceased doing banking business. Cheryl had done all that because it expanded. If we're talking about verifying signatures and handwriting, that information is available. Ms. Wilfong said I also had to verify his mental capacity at the time of drafting his will. That's not what I'm hearing here this morning.
Should those, well, let me ask the question.
The affidavit does not address that issue.
No,
The affidavit she has does.
We have a couple different affidavits.
The one you provided me does.
I don't think I gave you any.
Yes, you did. You gave me a copy of an affidavit that does that.
And I do believe I said to you that the witness, you have, those are notarized people. I said, they can verify, but when they notarize your signature, they're not verifying anything, they're just notarizing your dad's signature. They're not verifying, as you are on the whole draft will. That is 2 different things, like we said to you.
And the power of attorney that was submitted, 2 of your employees were witnesses. 2 of your employees were witnesses. One of your
I've not seen the notes.
I had it available and showed it to you that day. And then one of your employees was the notary. So you have 3 people within your own office within 25 feet that can verify his handwriting and signatures.
You're the one.
Let me ask you a question.
But there is.
Because it was not required by code that you had 2 witnesses. He was not going to do that.
No, that's again, you incorrect, or presenting information incorrectly. When you told me that, I called Cheryl and said, we need to have witnesses verifying my father's signature. And she said, well, we did a power of attorney and you should have that, which I did, had it in my hand at that time and looked at that. After that, I said, okay, that should solve the problem. Because Lisa Reeder was one of the witnesses. Carolyn Sue Tenney was another one of the witnesses. And then Christine Loudon Edwards was the notary, all employees of the Upshur County Clerk's Office. However, after that hung up, said, we've got 3 people in the office that verified the signature in January of 2012, and we should be good to go. Ms. Wilfong advised me they also have to be able to attest to his state of mind when he drafted the will, and that's not what I'm hearing here today. It's up to an heir or a beneficiary to challenge the state of mind, to challenge a will in those regards, as I understand it. If we need to provide those 2 witnesses, according to that court case that we have, that's easy enough to do. Getting the witnesses to the signature, there's 3 in her office at the present time. Mrs. Bennett has notarized my father's signatures many times. She can be a witness to his signature, not a problem. The problem is in the mental capacity that Ms. Wilfong was requiring on the attestation form where it deals with handwriting, signature, and mental capacity. That's 2 different matters. Maybe take 2 different people, 10 different people, I don't know. But if we need to get 2 people, we have 4 within the confines of the courthouse and annex. That can be accomplished today, hopefully.
Let me ask Terry this question. Should that have been sufficient?
Which?
The ones that, well, as far as the attestation of the signature.
No. If you sign a document, say a motor vehicle title before me as a notary public, I'm verifying and certifying that you acknowledge it as your signature. If I'm a witness on that, I'm acknowledging that I am verifying that you acknowledge that as your signature. on holographic wills, if you look at the case, they have to verify that they are familiar with the handwriting. It's that orange section there, I think page 3. Verifying that they were acquainted with the handwriting of the decedent. So I may witness your signature or notarize your signature on a card title, but that doesn't mean that I am familiar with your handwriting. In fact, if you bring me something tomorrow, I probably won't recognize your handwriting. So it's two totally different things.
If that's, the court case does require that, those two individuals can easily be obtained as to verify his handwriting and signatures. That won't be a problem. And that could be resolved fairly easily and fairly quickly. What Ms. Wilfong's additional stipulation, maybe that is now changing. If she's given me the wrong attestation form.
And I do believe, Mr. Parker, I asked you when you were in there Tuesday, when I signed the papers, that I said, why are you against having the two witnesses come in and verify his handwriting and signature? And your answer to me was, because it's not required by code.
It's my understanding it was not required by code. Now, if this court case does require that, we can comply with that. That's not an issue. What your additional stipulation is the mental capacity. That's the stipulation that we're having difficulty with here today.
That's not what you know.
Debbie, that is on your form. Ms. Wilfong, that is on your form. That is on your form.
We have several different forms. You are given the wrong form.
Then I suggest we get the correct forms out to people.
And I sent that to you the other day. Did I not? And your answer was again, because code is not required.
Code does not require it, in my opinion. If that court case has changed the statute, then we will comply with the statute in the court case. But if that case does not require mental verification of mental capacity, then you cannot require that.
That is correct.
Then I suggest we get it off of Upshur County forms, gentlemen.
Is that on all of our forms or just some of them?
Just some of them.
And are there some cases where that's required and that's why you use that form?
But that is a form that actually goes with when someone has done a will, doing their will, and the attorneys, that's more or less, like the attorneys use on the back of the will to verify the handwriting, to verify a will that the attorney uses.
There's requirements in what's called self-proving affidavit, which 95% of the wills have. That way you don't have to go through this. You don't have to bring in witnesses. You don't have to prove anything. So that is on the vast majority on the self-proving affidavit. And I can see how that could happen. But on this one, no. If he could, in my opinion, if he can bring two witnesses familiar with the handwriting, verify it's in his handwriting, and that is his signature, then this, we don't need to go any further and discuss it any further. We resolve it.
We can accomplish that if that's a requirement under that case. That won't be a problem. I can find those people. Now, as it relates to some of the other matters brought up here, Mr. Reed and Ms. Wilfong are correct on the insurance. But again, under the court case or the statute that I gave you there, the insurance on the non-probate is payable to Cheryl, who's an executor of the estate, not in her capacity as an administrator, which is different than an executor, technically. She is...
Actually, they have the same powers.
They have the same powers.
Executor is one who's named in the will. Administrator is either an intestacy or someone other than the person named in the will, but they have the same powers and performance.
Yes, they have the same powers and responsibilities.
Exactly.
It's just a matter of whether the will names them or...
Just whether they're in the will or not.
Whether they're named in the will, yes.
Whether they're appointed by the will or appointed otherwise. So that insurance would not need to be listed in this case. And
well, see, I was a little unclear on that. Is it named to her, period?
Period.
Was it named to her as personal representative?
Period. Cheryl Jean Parker, period.
Included, I agree.
Period.
But it has to be included in the non-code.
No, it does not.
No.
That's the issue.
I thought this was a named beneficiary, is what you said.
It has to be included if it's payable to a named beneficiary other than the executor of the estate. This is where we're having issues. It's clear black letter, and then you have interpretations otherwise.
I haven't seen, you showed that to
Yes, I showed that to you.
Over Lisa's desk the other day, but I haven't looked, sit down and
Yes,
looked at it.
it does not have to be
And
listed.
that's what I said. If it's made payable to the estate or it's made payable.
If it's payable to the estate or the executor or administrator functioning in the capacity, it must be listed, but that's not the case here. The bank balances, I'll take a look at that. I don't know what, Freedom Bank and the Central West Virginia Telephone Credit Union, what forms they would have that could verify a bank balance at the time of his death on November 30th. We have luckily, the Central West Virginia Telephone Credit Union, that's their time period for mailing statements. So it's within a few dollars, but it's not exact and never will be.
Terry, are you saying in that situation, then it's up to the bank then to do a reconciliation at the
No,
date?
they
Or?
don't do reconciliation. They will give you a form signed by the bank that says on November 30, 2012, the balance in account number blah, blah, blah was $12,326. That's what you use to verify. Now, the reason we use this, and I'm hesitant to say this because I don't want anyone to say that I'm implying anything. I'm not. Willie is a man of fine character. I'm sure that there's absolutely, positively no bad intent in his heart. I want to make that clear. But the reason we require the banks to verify it, if someone else who, and remember, what you say here is going to apply to everyone, even someone who has felonious intent in their heart. That's the procedure if you change it. If that bank account, let's say, is $155,000,
We could only hope.
and I want to buy a new truck for $30,000. All I got to do, if I don't get it verified by the bank, I just put down $125,000 registration. That's all I got to account for. That's all anyone's aware of. And I got over $30,000 to do with what I want, as is evidenced by a recent event in this county. That's why we require the banks to verify.
In this situation, the banks or the bank accounts are not just in my father's name. They're joint accounts with Cheryl, and she has the authority right now to spend all that money as she sees fit as a joint owner of that account. So, I mean, that is a moot point in this matter as it relates to this estate. We can get a statement from the bank easy enough. It's not going to correspond with the numbers that we list on the non-probate inventory because we're listing the actual balance, not what the bank says is there, because that's not what was there. As long as Ms. Wilfong understands that, we won't have a problem. It's easy enough to get a piece of paper from the bank that bank balance on such and such a date was this. It won't necessarily correspond with what's listed on the non-probate inventory.
But that's all you need. You just need a statement from the bank saying that as of this date, the balance was this. So if you had $150,000 in the day before, you'd written a check for $100,000 and hadn't come back to the bank, they're going to say $150,000.
I'm going to show up. I have to account for everything on that appraisal. So I'm going to show a beginning balance of $150,000 on my final settlement. Then I'm going to deduct that $100,000 check, and I'm going to balance out. Now, on your non-probate,
Non-probate's where it's going to be listed.
you do have to list life insurance to named beneficiaries on the non-probate. Any representation to the contrary is wrong.
1111.7, I think it is. Let me find it here in your statutes.
There's the appraisal form.
I understand. I understand. 1111.7.
Question to you, sir, please. If we have provided a bank statement showing the amount as of November 30th, and also we've provided as far as what my check balance is, showing what checks, well, we've provided those.
I've got that, yes. I've got those. November 15th is the Freedom Bank.
I think we can solve, are the bank accounts solely in his name? Or
No, joints.
And she's not going to have to account, it makes no difference. Just
I know.
The bank shows because she does not have to account for that.
I understand that. I understand it's non-probate. The only thing on the appraisal on the probate is one savings bond for $100. personal property of $500. That's it. We're not talking about scads of money here, folks. 11.11.7, if anybody wants to write this down and research it. Item 4, insurance on the decedent's life payable to beneficiaries other than the executor or administrator of the decedent's estate. To me, that's pretty clear.
I mean, not to be contrary here, but that's because in that instance, that property is considered probate. That property, that proceeds, life insurance proceeds, are considered part of the probate estate. And because they wouldn't be listed on the non-probate inventory, they have to be listed on the appraisal in that instance. That's why that exception.
Well, I mean, we can list that, that's no problem. My problem with listing it is how we handle the records. There's no reason to keep them a year. If you need a form, you can call the state tax commissioner and they can send them.
And I might just interject that what Mr. Parker said should be true, but is not true.
I understand that. I understand that.
Once they've been
I understand
to the
that.
state tax department, you
Believe
can't
me.
get them back. And I would just like to point out, as one of the fiduciary commissioners, often it comes up, there are a list of people who are entitled to a copy of the non-probate. The public is not, but there's a short list of people who are. And so what happens is a relative calls my office and says, I want to see the non-probate. So I call the executor who says, why didn't you keep a copy? So I called the state tax department who says, well, we don't have a copy. The only copy that I could possibly get would be the one that Ms. Wilfong was thoughtful enough to keep so that it could go pursuant to code to the people who are entitled to it. So
I would concur with that.
you ought to be able to get to the state tax department, but you can't. And I'd also agree with Mr. O'Neill that I believe the 1111 statute is referring to when what would normally be non-probate asset has actually become a probate asset because it's being paid to the executor as executor. The fact that his wife is his wife and the executor is different. She's getting that money as his wife. That makes it a non-probate asset. If she was getting that money as his executor, that would make it a probate asset. It's got to be on one form or the other. It cannot be excluded.
Would you agree with Mr. Reed that that after a year, now you're saying, Terry, a year after the will's settled?
There's various time periods for various things, and they keep changing them. It used to be you could challenge a will within 5 years. Now I think it's what, 1 year?
1 year. In my opinion, once the estate is closed, obviously the time to challenge will has well passed. And so once an estate is closed, which in theory takes 5 years, but of course the commission, as you all know and regularly do, can extend those. There are estates, right recently, the Stockard estate finally closed just recently, so an estate can take a while. Once an estate is closed, those non-probate forms could be destroyed with no harm. But in my opinion, they cannot be destroyed until an estate is fully closed. And I would suggest, as an attorney, we always err on the side of caution, perhaps a year after the estate is closed, just to make sure all our abuses are well covered.
But do I understand, Debbie, we have all of them, and what you've been doing and plan to do is to continue to keep them forever, all of them?
That's what, I mean, it's never been an issue before. And so, I mean, the files that I have now are in my office. The public does not have access to them. The ones in the back are locked in the back room here, in the bathroom.
Which back room is locked?
The second back room here.
The one that says employees only on the sign that the door's open?
And no other than employees are supposed to be in there.
I know, no, that's what the sign says, but it is not locked.
We can put a lock on it,
Yeah,
if that's what.
that's my problem in storage of these records. It's available, someone's back in that middle record room, there's a sign there that says employees only. They walk right through that door.
So,
That's also where you're keeping your DD
We don't put a
214s.
lock on that door.
but it's not locked now, is that what you're saying?
No,
It has a lock, you have to unlock it again, but no, you can actually, if someone wanted to lock in there. I have never seen anyone, and I don't know who my other employees have, why would you call up in those cabinets and even look for it?
Unless you wanted to get something that was in
We
there.
get a lock and put on that door.
Okay,
We will get the locks changed and get
okay, all right,
the medical.
excuse me. All right, anything else, does that cover it?
no, I'll have 2 people here today, if they're available, to verify his handwriting and signature. They will not be able to verify to his mental capacity at the time of drafting.
But
the
you're
will.
saying that you gave him the wrong form and that doesn't apply?
That is correct.
Okay. Okay. Well, we thank everyone. It's certainly been an educational process for the commission, so that's for sure.
And for the public at large.
Right. Okay. This time we have Virgil Miller, Chief Deputy of Administration, Care, and Cost of Boarding Horse at Walter Sinclair, October the 12th, October 2012 through March 2013.
If you don't want to speak from that.
I'll be back.
Morning, Virgil.
Morning.
Good morning, good morning, good morning. Well, that's,
You've got a horse, do you?
I can nowhere come near your all's. No, I'd just leave it at that.
You could have a problem with the sound mind part of it.
Yeah. yeah.
Was the county willed this horse by someone?
Well, I'll explain this. Here. Let me start off. Little history. Back at the end of September of last year, 2012, we had received at the sheriff's office a call about a emaciated horse that wasn't being taken care of right adjacent Route 20 down at Rock Cave. Lieutenant Mark Davis proceeded to follow up, and if I recall, that was Labor Day weekend. It was a long weekend that weekend, I believe it was Labor Day. And he actually did go down, he saw the horse, he was concerned about the condition of the horse, and made contact with the owner at that time, and her name was Pauline Teft, and he directed her that this horse needed immediate attention, and she needed to act on it. He followed up the next day, could not make contact with Ms. Teft, learned she was in the state of Ohio. The horse was still there. It was in a paddock of a wooded area, rocky. There's no vegetation, no grass or anything for the horse to eat. There was a little bit of hay there in the field. And pursuant to that, Monday, we still hadn't heard from the owner. Lieutenant Davis and I both traveled to that residence. And are you going to leave, Tom? Jeez.
Sorry.
Tell you what. But we traveled down that morning, follow up, and immediately going to the residence, no one responded to us. And at that time, this is what we observed. And Mark and I both agreed at that point in time that we needed to move to save this animal. And I had talked with some horse people in and around Upshur County. I talked with Mr. Sinclair and advised him of our situation. He agreed that if need be that they would take this project on, he and his son. If you see the first picture is what the horse looked like when we seized it 1st of October. That picture, the second page, it was taken about 2 weeks ago. By the way, her name's Fancy. She's about a 20-year-old Tennessee walking horse. Very gentle, very good-natured horse. And so Mr. Sinclair and his son came down that day, and we immediately removed that horse from that location, from that residence. And Mr. Sinclair took it to his farm, located out on Peck's Run here in Upshur County. And he has been taking care of the horse. Actually, I helped him, and my son and I, some of your county employees also, because for about the first 10 days, she would lay down. She didn't even have the strength to get up on her own. We had to roll her onto a homemade belt system and lift her with the tractor to get her on her feet. But she's doing well. We had her vetted and looked at. And Mr. Sinclair, I've looked it over, and he submitted a bill for the care and taking care of this horse up to this point till the 5th of March. He's been boarding the horse and taking care of it. And she's still not 100%. She's pretty well, maintained. She's gained probably about 300, 350 pounds. So she's doing good. And there's the bill he submitted for the sheriff's office for the care of this horse for the past, what, 5 months, 6 months? And, you know, hay, he's charging $3 a bale, which that's well within the cost of a bale of hay, and 2 bales a day. And like I say, he's worked with her, and we're the owner of the horse, Mrs. Teft, was charged with animal cruelty. She appeared on the 9th of October, and she entered a plea of guilty. She was sentenced to 60 days in jail, and she was required to serve 30. And 30 days, she was put on 2 years unsupervised probation. She's not allowed to own or maintain any animals for the next 5 years. I checked the court record, and I have a case history. She has paid her court fees and her.
She has or has not?
She has. $434.30 is what she paid back to the county. Of course, we didn't anticipate, you know, how you couldn't project how long you was going to have to maintain this horse.
Is it possible to seek restitution for the cost to the county for?
I think if we did, we'd have to go through a civil issue route. Yeah, because the criminal, she's already taken care of.
So what are we going to do with the horse now?
What I've been working to do, and actually we have 2 interested parties that are interested in adopting the horse. Mrs. Teft signed over in court on the regular animal control form the possession of the animal to the county. And like I say, we're looking, Mr. Sinclair's, he has 13 head of horses himself, so he's not particularly interested in keeping her. But he shares the same concern I do. I want to see her go to a good home where she's going to be cared for and never again be anywhere near the situation we had with her at this time. But like I said, we have 2 interested parties. One gentleman lives in Lewis County, one lady's here in Upshur County, and she's interested in adopting Fancy. And as you well know, the recent horse sale they had Sunday at the Buckhannon Market, horses for the last several years. You know, I've got 4 myself. I know what horse flesh brings, and horse flesh doesn't bring too much. They had two broke Halflinger workhorses out there that brought $200 a piece last weekend at the sale. So, you know, there's no value per se other than this is a creature that we want to see, you know, have a good life for the rest of what she has left.
So how soon would this adoption take place?
We're the one lady, I think you know Sharon, works as an intern. She's down here. Her husband's the manager of the for the old Moore's business. Right. She's looking at adopting. Actually, she's been talking with Toby Bennett about boarding the horse at Toby's and so forth. So that's who we were looking to.
So we'll have, this was through what, March the 5th, so we'll have the additional expense through till the time it's adopted? Is that? Well,
I can get on the move, but I would hope maybe before the end of this week or the first part of next week have that secured, have it done.
But will we owe this gentleman more money?
If it is, it'll be very minimal.
Well, I'm just thinking if we...
I can follow up with
check and see, and then that way we won't have to write 2 checks. I mean,
right.
Write one for the full. Once we know.
Let's consolidate them both.
Mm-hmm. And if he says it'll just be from the 5th up to what's today, 28?
You can find out.
21 days, see what
we can go from there. You need this back, Virgil, for your copy?
Yes, sir, I'd like to. I can make you a copy.
No, that's fine. Here, man. Okay, well, go ahead.
How much is the bill?
What was it, $2,500?
$2,535. I'll break it down. It's $3 a day per bale of hay. It was 2 bales a day, so it'd be $6. Total of $900. Transportation for the day they came down and picked her up was $50. Out-of-pocket feed for the first day he had her was $85, and then care and fuel and associated costs is $10 a day, totaling $1,500, which I think is very, very reasonable, you know, for keeping an animal. And A little story about Walt. I know Walt personally, he and his family, and he would get up at 11 o'clock at night, and he keeps her in the barn every night in the stall and checks on her. So she's been very well taken care of.
Well cared for.
Yeah.
Well, it's a shame that people have animals and don't take care of them, because time you factor in 30 days in regional jail, then the taxpayers paid about $4,000 for that, someone not taking care of their animal.
Right.
But
That's all I have. Do you have any other questions?
Any other questions for Virgil?
When did the person plead guilty to the animal cruelty?
I think it was on the 9th of October, if I remember right. Yeah, 10/9 of 12.
Did she give up her rights to that horse?
That day.
That day, you have that's what you have there, the document, that she gave up her rights to the horse.
Well, then from October 9th, if she gave up the right for this horse, seems like we're getting a pretty good bill here, you know what I mean, for keeping this horse from October to March is my concern.
Exactly. I know what you're saying, but you got to factor in the fact of the condition of that horse, that, she needed attention daily to get her back on her feet to where we could have her in a position to adopt her to somebody.
I understand that, but that's pretty good cost to the county.
Yeah, and you factor in, I know where you're going with it, you're looking at, well, would we have been better off to euthanize this horse and put her down? It's a creature, and I think she had the will to live, and I know it sounds, kind of like we spend a lot of money on a horse that's not worth anything, but still it's an animal that I think deserves the right to live.
Okay, any other questions? All right, thank you, Virgil.
Okay.
Let's take a little 5-minute recess.
And you need this back, Virgil?
No, I made that copy for you.
Okay, we're back. We have some more items for discussion and possible action. First being resolution to approve court security fund grant program to increase courthouse security within Upshur County for $38,176. And I believe, Megan, you've been instrumental in getting this grant, so why don't you talk a little bit about exactly what it's going to accomplish.
Okay. Well, the grant is for $38,176. We've applied for this in the past, but I think the last time was in 2009. And this is just basically to purchase equipment to increase security within the courthouse, so more surveillance cameras, that type of thing.
Okay.
I didn't include the entire grant in your agenda packet just because of the nature of the grant, but it's basically just for increased surveillance and security.
It's for material cost, equipment cost. Okay, do we have a motion to approve the court security grant program? And
I have a question.
You have a question?
Yeah, or an observation.
Yes.
Observation.
And do not accept this as a negative, or so just an observation. But the grant is for equipment that would be toward increasing security in the courthouse.
Correct.
In light of all the other activities that have occurred throughout the country in terms of random violence acts, this would be something that would be a precautionary measure to ensure that the safety of the employees and citizens who visit the courthouse is upgraded. I notice there's no dollar figure. It is for equipment only, but equipment has to be manned, does it not? At some point.
Well, some equipment, some not.
Right.
I mean,
Right.
the surveillance is viewed by employees that we already have, the 911 dispatchers, the individuals in the offices around here, so they already do that.
And the logical progression would be to add additional security procedures in the future, I would think.
Yeah,
I'm not
I mean,
opposed to those. I'm just saying that
This is going to increase security a great deal and be really helpful, especially in some equipment that we already have, making sure it works correctly, enhancing it. But it certainly, there are other issues that we probably could address in the future. I mean, this probably won't be the last.
Sure. And so at some point, there will be increased costs. Like typically, we'll get something from a grant. I'm not singling this grant out, but it's typical that we'll get a grant from either state or federal sources, and then at some point, the costs revert to us and might include other expenditures. I know some counties, for an example, have magnetometers, and that have to have deputies or court security type people monitor those, so that those are expenses that down the road we may have to inquire, or incur rather, result of that. But I support the grant, and I will move that we accept, or make application for the grant.
Okay, we have a second to the motion.
I'll second it.
All in favor, say aye.
Aye.
Opposed, same sign. Motion carries.
I think, Commissioner Rafferty is correct. We eventually are moving to a controlled entrance standpoint. But I think I'm correct in this. This grant would not pay for personnel.
Right.
Most of them, in fact, do not. But it's putting some equipment in place. But eventually, unfortunately, we're probably moving to the controlled access entrance.
Well, you have a situation here in the commission where, and you want to be open to the public. That's the primary function of government, is to have accessibility to the, but as we've seen in a number of locations and places, public business sometimes it can be a target for those that are not stable or have issues. And Lord knows we have issues in the county commission.
You have to watch out for big purple people.
That's right. So, in any event, I appreciate your efforts, Megan, on securing that, and hopefully it'll go through. Buddy, Jess, anything to say? Or?
No matter what you do for security, if somebody has their mind made up to do something and doesn't care what the cost is, having this grant and having cameras and so on will not be, maybe a deterrent. It will not stop somebody that's got his mind made up.
Or her.
Thing does that as an officer that has a gun already drawn. I hope he's a good shot.
Sometimes that doesn't even.
Sometimes he's just the first casualty.
Okay, next item is approval and signature of resolution and contract to accept community participation grant awarded to Upshur County Public Library for $5,000. And
do we know what this will be used for specifically?
to upgrade technology at Upshur County Public Library.
They'll be purchasing 2 literacy stations, so they're computers that are geared towards children that are, I think, between the ages of 2 and 8. It's all educational programming for kids that don't have access to technology at home.
Okay, sound like a good. So we have a motion to approve and authorize the president to sign the document.
I'll make that motion.
I'll second it.
All in favor, say aye.
Aye.
Opposed, same sign, motion carries. Next item, consider request from CERT team to utilize Upshur County parking lot located 58 South Locust Street as a first aid cooling station during Strawberry Festival, May of 2013. That's the paved lot, Jim, down in front of the extension office? Is that
Well, I'd ask for either that area or the one across the street that's gravel, either place.
Okay.
We normally have that station set up at the intersection of Bogus or Bogus, however you want to pronounce it, Route 20, and we're not sure if that site's going to be available to us, so we're looking for an alternate site.
And that address that I listed there is, I understood you to mean the gravel parking lot right across the street from here behind the church. So that's the address listed there.
Okay.
But
I believe the residents call it bogus, rather than bogus.
But normally they set up 2 of the 10 by 10 pop-up canopies, and we provide drinks and water. We have a couple people who are nurses that actually we've helped, parade participants in the past, and people get really overcome with heat. Well, they give water or drinks out to anybody. So it's proven very beneficial in the past, and it's kind of moving it up this way is going to take it a little bit more out of the midpoint of the parade, but still it's going to be in an area where I think they're a big benefit to people who are going to have some health issues.
It's been, I know, you can't predict the temperature or the weather on a particular day, like especially in May, but there's been days when it's been like exceedingly humid and hot, like 100+ degrees. And there's other days when it's been close to freezing. But it's unpredictable as it is, but it's important that we have
So we've had some
precautions.
Some heat issues in the past couple of years. I think it's beneficial that it's there.
So,
It's another place too, people can get direction if they're not sure where they're at, how to get here, how to find a restroom. So it provides a lot of service.
so specifically, you're asking for the gravel lot
That would
across the
be,
road. That'd be your prime choice.
but it doesn't matter, either
That'd
way.
be your prime choice.
Okay, we just need to, there's we need to coordinate as far as the parking, and also then need to some way dedicate that, because there's a lot of people that set up in there, so
We just need a
some way get that determined and dedicated, so we
Yeah, I would probably ask Jim to get with the Strawberry Festival Board to communicate to them. We'll put up, Jim put up some signage or,
Right.
a day or two before.
Right, maintenance is going to help if we need
We're
to.
going to start meeting with them, our first meeting, I think, is on the 8th. Just go over our, pre-plans for the festival, so we'll include all that.
Yeah, 'cause if I'm not mistaken, I think the Gibson Fire Equipment Company has used that area before.
Well, they've
Now,
set
they
up-
still may be able to, I don't know how
Well,
much area we're
they
talking
usually
about.
set up in the, what now is the bank's
Is that right?
gravel lot.
Right.
So, but you can coordinate all that.
Yeah,
So,
and if we have to stay up one way or the other way,
Right.
I don't think it's a big deal, but as long as we can put up those two canopies, I think that's going to take care of our needs.
yeah. Okay, sounds good. Then, do we have a motion that we honor this request?
I make that motion.
I'll second it.
All in favor, say aye.
Aye.
Opposed, same sign, motion carried. Consider,
Thank you, sir.
Jim.
Thank you, Jim.
Consider approval of 2 volunteer applications in Upshur County, Travis Hume and Hope S. Moore. Is that for out the animal control facility? Or?
Yes.
Okay. And that comes from Jan
Yes.
with her blessings. Okay, do we have a motion to approve these 2 volunteers?
I make that motion.
I'll second it.
All in favor, say aye.
Aye.
Opposed, same sign, motion carries.
If I remember correctly, it's individuals that are needing some community service through high school for graduation requirements.
Okay, that's good. Okay, approve Mid-State Soccer's Club's use of Pringle Tree Park for practice Monday through Thursday, 5 to 7, March the 1st through May the 31st, 2013, adding Monday to the original request. So, have we already approved the request everything except Monday?
Except for Mondays, yes.
We're just adding the Monday. Do we have a motion to approve that request?
I'll make that motion.
I'll second that.
All in favor, say aye.
Aye.
Opposed, same sign, motion carried. Okay, we have a notice of public hearing, amendment to enhance 911 ordinance, 11 a.m. on Thursday, April the 4th, 2013. Increase from the current monthly fee of $2.65 to $4.50. Business interest, $6.50. We have an environmental report on proposed extensions to water distribution system for Adrian Public Service District of Upshur County, prepared by Horner Brothers Engineers, 16 through 29, for your reading pleasure. That's all part of the required documentation and reporting for water line extensions. And since Upshur County Commission is the recipient of the Small Cities Block Grant Awards, you can certainly look at that and get knowledgeable information there. Well,
I would like to note that we do have a vacancy on that board due to the passing of Sharon Bowen. And I would request that Willie or Megan contact Mr. Killingsworth to determine whether they have a applicant or a replacement that they have in mind and provide us with that.
Okay.
I have another individual that might be interested in that position. If it is, because that's a county position that's vacant, I believe. is it not?
Yes, they're appointed by the county commission. I'll contact the Adrian PSD and request follow-up.
Is Killingsworth still with the Adrian?
Yes.
Yeah, the current members are Don Killingsworth and
Darrell Bloughton.
no, he was replaced by Jack Simons.
Okay.
Yeah, Jack Simons, and then Ms. Bowen was.
okay, any other questions, comments? Well, I'm sure we have some paperwork.
Do have a little bit of paperwork. Just as a note also, you have a special meeting that's scheduled on the agenda for April the 16th at 10 a.m. That's a mandatory meeting for all governing levying bodies to adopt the levy rates and final adoption of the budget. It has been submitted to the West Virginia State Auditor's Office, and they'll be performing their review and sending a their notice of approval, conditional approval, or non-approval.
What date is that again, Willie?
April the 16th, Tuesday the 16th at 10 a.m.
Here at the courthouse.
Right here at the courthouse. It's statute. Every governing body must meet that day to do that.
Okay, anything else? Not, we will start on our paperwork.